All rise. The Court of Appeals Division 1 is now in session.
Thanks, everyone. Be seated. Thank you. Good morning. We're here for oral argument in State of Arizona versus Rodney Lynn Dalton, CR21 0201. As you know, we record and live stream these proceedings, so please give your name and the name of your client when you stand up. Our current protocol is that you'll each be arguing from your podiums. You have 20 minutes per side, although you're not required to use all of your time. We do require you to keep track of your own time, including whatever time that you're reserving. Keep in mind, we have read the briefs, we've studied the record, and we have also conferenced this case. And with that, Counsel, you may proceed.
Is it okay if I remove my mask during
Yes,
argument?
that's
Perfect.
fine. Thank you.
Elizabeth Garcia on behalf of defendant Rodney Lynn Dalton, and with me at counsel table is Lori Vopel. The 5 issues raised in Rodney's opening brief interact and all worked together to deprive Rodney of a fair trial. Each issue was individually prejudicial, but in the interests of time, I'd like to focus on 3 of those issues. Unless this court has any questions about the duplicitous charge or the additional days of pre-sentence incarceration credit Rodney's entitled to, I'd like to address the Rule 404, inadequate notice, and cumulative prosecutorial misconduct claims today. I'm going to start with the erroneous admission of other act evidence today because that issue standing alone constitutes reversible error.
Let me ask one question on that.
Yes.
As I read the brief, there's no specific other act evidence. It's the cumulative other act evidence that you have an issue with. Is that correct?
There is specific other act evidence that was admitted on pages 28 to 40 of Rodney's opening brief. We identified and even bullet pointed numerous instances of specific other act testimony adduced at trial that were objectionable. Now, unfortunately here, the volume of other act evidence introduced was so excessive that it predominated the trial, but that doesn't render this cumulative error claim as the state has argued.
What was that evidence probative of? Leaving aside any improper prejudice, what was it probative of?
My understanding is that the state's contention was it was probative of MD's credibility, as well as constituting critical background information explaining why JD wrote the letter that he wrote, explaining why MD didn't divorce Rodney earlier than 2015. However, as noted in Chantry, which this court decided just last year, the fact that information may be relevant as critical background information doesn't render it exempt from Rule 402 or 403's requirements. And here, the trial court failed to subject the 404 evidence admitted to that critical analysis. And that is an abuse of its discretion under Garcia and Anthony, which Rodney cited.
This is an unusual criminal case, I think, because there's a lot of family court in it, much of which appears to me to be completely collateral to the charges.
Correct. There were no child abuse charges. That is undisputed. The only charges Rodney was faced with were the 4 sexual assault and 1 kidnapping charge that arose out of the 4 encounters with MD. Rodney and MD were the only witnesses present for 4 of those 5 charged offenses, and their daughter, HD, testified about circumstances relating to the 5th charge. The child abuse evidence was highly inflammatory, highly prejudicial, and had no bearing on whether Rodney committed the charged offenses. All it did was encourage the jury to convict Rodney because he was a bad man who abused children and, as the prosecutor argued, couldn't take no for an answer when it came to child abuse or sexual assault. And had the trial court submitted this evidence to that critical analysis that was required under Rule 402, 403, and 404, that evidence would not have been admitted.
And okay, so let's say that that's the case, and the evidence shouldn't have been admitted. If it hadn't been admitted, is there any real prospect that the result would have been different in this case?
Yes, but I would like to direct the court first to the applicable standard of review. The burden of showing harmlessness here is on the state, not on Rodney. fundamental error review doesn't apply here because the record is clear. Rodney repeatedly objected to the introduction of the 404 evidence, to the deprivation of his right to present a complete defense. The harmless error burden falls on the state, and on this record, they haven't even argued in their answering brief that the introduction of the 404 evidence was harmless. So we've argued that even if they had attempted to meet that burden, they wouldn't have been able to. There was not overwhelming evidence of guilt here. This was a credibility contest between MD's testimony and Rodney's testimony. There was no physical evidence, such as DNA evidence, that could have supported the state's case or Rodney's defense because so much time had passed.
Well, how could DNA evidence ever have supported this? I mean, or refuted it?
It could have demonstrated that, in fact, the couple had had a sexual encounter on the specific dates alleged. A medical exam might have provided evidence that maybe an assault had or had not occurred. But again, because these
issue here, I understand there's a violent component to the allegations, but the issue here is really one of consent. So I don't see how forensic evidence would have been terribly relevant.
It could have supported Rodney's alibi defense, right? Had the evidence shown that they had not had a sexual encounter around the time that MD claimed these encounters had occurred, it could have supported the defense or it could have supported the state's case. Now, I'm not arguing that evidence would have been dispositive. My argument is because of the time that had passed, the only evidence that the state proffered of these charged instances was MD's testimony. And again, on this record, MD was, she was not the most credible witness. The state, and as the prosecutor recognized, she had to explain why would a child write this letter accusing his father of physical, emotional, and sexual abuse? Why would MD have stayed with Rodney for all these years if these encounters had been occurring? And she knew that she had to get these issues out in front of the jury to bolster MD's credibility.
Why would the victim stay strikes me as a question that might have been asked 50 years ago, but it's fairly common in our experience that victims do stay. It doesn't seem to me that that's really the inquiry anymore. It's more, did the acts occur?
Perhaps not, Judge Swan, but it was an inquiry the state and the prosecutor thought was relevant to their case. If you look at the opening statement, it was the state that introduced MD's motivation for divorcing Rodney, for not leaving him sooner. She addressed that same motivation. She put it at issue in the opening statement and direct examination of MD. That was part of the basis for justifying the floodgate, the flood of other act evidence that was admitted here. And we agree that evidence should not have been admitted, even if it had some minimal relevance to explain her motivation for divorcing Rodney. The minimal probative value that it had didn't outweigh its highly prejudicial content.
I know that this isn't a PCR petition, but I don't see anything in the brief suggesting that there's even a hint of actual innocence. Have I missed something?
Actual innocence isn't a claim we can address on direct appeal.
Understood.
And so
but even atmospherically, I'm not seeing in there the notion that substantial justice wasn't done. I'm seeing the argument that this trial was conducted in an overly aggressive and perhaps you might say slipshod manner, but I'm not seeing a claim that the actual evidence bearing on the claims itself is deficient, just that a bunch of collateral evidence probably shouldn't have been admitted, in your view.
We have indirectly made that argument by arguing that there was not overwhelming evidence of Rodney's guilt. Rodney denied that he had ever sexually assaulted MD, and even MD admitted that they had on many occasions had consensual sex during their marriage. So, was there an outright denial that the couple had not had sex during their marriage? No, there wasn't. But was there a denial that sexual assault had occurred? Yes, there was. And if the jury had been forced to weigh MD's credibility against Rodney's credibility without the influence of this highly prejudicial, inflammatory other act evidence, it could have found Rodney's testimony more credible, particularly because it wasn't plagued by the questions that rendered MD's testimony questionable.
Counsel, can I, one of the arguments that is raised is that the state opened the door in their opening statement.
Correct.
So I've gone back and looked at your, the transcript and where you quote, you give examples of where you feel like the state opened the door.
Correct.
Help me understand, walk me through that, how the state opened the door during their opening statement.
Okay, so the opening statement sets forth the evidence the state anticipates presenting at trial in its case in chief. The prosecutor was warned before opening statements that she needed to play it safe. The trial court had ruled at that point the door was not open to the admission of any other act evidence merely because Kibbe had been noticed as a witness. Despite this, the prosecutor, during her opening statement, argued, well, MD suffered sexual assault by Rodney over a period of years. Not just persistent sex, but it was outright forceful, angry, aggressive sexual assault. She also specifically referenced the sexual assault that was uncharged that had occurred in the shower, in which Rodney first forced MD, allegedly, to engage in anal sex with him in the shower while she cried and said it hurt, and then forced her to have vaginal penile penetrative sex while in the shower, while she said no, crying. That was another act. That was opening the door to this trend of testimony that said that Rodney was constantly raping MD during the course of their marriage. The theme of Rodney not being able to take no for an answer, and that his inability to take no for an answer had been addressed in counseling on several occasions, that was introduced during the state's opening statement, as well as references to MD's diary, in which she referenced these sexual incidents with Rodney. The prosecutor also opened the door to an explanation about the tumultuous divorce. She addressed that during her opening statement. You know, the court-ordered visitation with the kids and Rodney. She brought up JD's letter to law enforcement and his desire to be heard about not wanting to visit Rodney because of emotional and sexual abuse he had experienced at home. This opened the door because it told the jury that evidence supporting these allegations that had nothing to do with the charged instances of sexual assault involving MD and Rodney was going to be introduced to trial. And true to that promise, true to that indication of what was intended by the state, she did elicit that testimony during MD's direct examination before Rodney ever asked a question in this trial.
Thank you.
Unless this court has any other questions on the admission of other act evidence, which was highly prejudicial and constituted reversible error, I'd like to move on to the notice argument. So context matters to the insufficient notice Rodney received due to the indictment's broad time ranges and Count 4's erroneous amendment. As noted in the briefing, 4 of the 5 offenses had broad month-long time ranges, and only one count, Count 4, identified a specific date, March 1st, 2012. So this broad time range didn't describe the offenses Rodney was alleged with sufficient specificity to enable him to prepare a defense. He had noticed an alibi defense before trial in IR 84, the amendment notice of defenses. And it was hard enough for him to defend against the broad timelines, but then when the prosecutor introduced overwhelming other act evidence suggesting he was constantly assaulting MD, MD then surprised him at trial with a specific testimony setting a date for Count 5, and then the erroneous amendment of Count 4, which deprived him of the fruits of his effective cross-examination of MD on when and where she alleged Count 4 had occurred. This deprived him of that noticed alibi defense. It's undisputed. Rodney and MD spent a lot of time apart during their marriage due to their work commitments. And again, he did notice that alibi defense before trial. He could have reviewed his work records like MD did 2 days before trial to establish a defense to a specific timeline, to a specific date, had it been alleged. He could have, as he did with count 4, have effectively cross-examined MD on when and where she alleged these offenses had occurred. But these broad time ranges didn't allow him the benefit of the asserted defense, of the notice defense. That amendment to count 4 kept that target moving, because as soon as he attacked one count, it shifted to a broad 8-month time range. And again, the evidence shows that Rodney and MD were separated for much of that increased 8-month time range. The amendment wasn't supported by the evidence because MD being uncertain about when exactly count 4 occurred doesn't justify that 8-month increase in the time range. So in sum, Rodney wasn't given adequate notice to reasonably rebut the charges against him, in addition to being deprived of a fair trial by the erroneous admission of other act evidence. And it's in this context that I'd like to highlight the prosecutorial misconduct that occurred. The court has read the briefing and, has, I assume, read Vargas, which clarifies the 3 elements that Rodney must establish to assert a cumulative prosecutorial misconduct. He is not required to argue that each instance of misconduct individually deprived him of a fair trial. He also does not have to separately assert prejudice. In Rodney's briefing, he specifically identified and addressed each of those 3 elements. He asserted cumulative prosecutorial misconduct exists. He cited to the record and legal authorities, setting forth the reasons why the conduct identified was prosecutorial misconduct. And he set forth the reasons why it deprived him of his fair trial while citing to legal authority. In the interest of time, I'd like to reserve the remaining 4 minutes for rebuttal, if it's okay with the court. Thank you.
When you're ready.
And Judge, may I also remove my mask?
Yes.
Thank you, Your Honor. My name is Joshua Smith, Assistant Attorney General representing the state of Arizona. Just for the court's attention, the victim is in the courtroom observing the proceedings today. Dalton fails to establish any error that entitles him to a new trial, and as such, this court should affirm his convictions. I will begin by addressing the other act evidence. Dalton, in this case, opened the door to the other act evidence that was admitted during the trial, and therefore he's not entitled to relief, in part because he opened the door, but also because all the other act evidence was properly admitted during the trial.
Counsel, what about the position that your colleague had advanced? You gave the example of the incident in the shower. That was not a charged offense. That was raised in the opening statement.
Well, the incident in the shower was intrinsic to count 5. As the opening brief points out in their duplicity argument, the state elected which specific act for count 5, which included the victim discussed the incident in the shower and then the later one which the state elected. So it's part and parcel to what was charged. The prosecutor detailing that Dalton had repeatedly sexually assaulted the victim during the course of the marriage is also just previewing the charges, because the charges are 4 separate sexual counts that occur in different years. So the state's opening statement did not open the door to other act evidence. It did not impermissibly preview other act evidence. And to the extent that the state went into some of the other act evidence during their cross-examination of, the direct examination of the victim, it's really very generalized. It's discussing just the background of this situation, specifically their marriage relationship, that they went to marriage counseling. They didn't go into any details about it during the direct examination. When they're talking about Dr. Foreman's notes or the counseling with Dr. Foreman, all the victim said is they went to talk about the sex issues and issues related to the children, which doesn't indicate any sort of abusive behavior. And when the victim on her direct examination started going into details that the court said that they could not go into, the prosecutor stopped her and made sure that her answers were limited to just as general as possible to avoid bringing in the other act evidence before Dalton opened the door, which he did in his cross-examination of the victim. When he cross-examines the victim, repeatedly asking why she didn't leave him. I believe the phrase the defense counsel uses, "Where's the hammer?" when talking about setting boundaries and how does she enforce those boundaries. The defense counsel also cross-examines He also asked the victim about the children running away to Walmart and them being arrested by law enforcement for refusing to participate in visitation. So he goes into a level of detail with his cross-examination of the victim that really opens the door for the state to explain why she ultimately did leave the defendant, why the children did not want to participate in visitation, and
Why is there so much focus on that issue? Why is it even relevant whether the children wanted to participate in visitation or whether he was the father of the year? I mean, I cannot see why that belongs in the trial.
Dalton put it in the trial. The state tried to keep this evidence out. They filed their motion in limine to preclude Kibbe's testimony. For this very reason, Dalton, in his opening statement, laid out these issues. He laid out that the victim had a diary entry where indicating she was jealous of her relationship or the defendant's relationship with the children. He insinuates in his opening statement that the only reason that A, the victim wrote the letter, and B, she wrote the letter because she was upset with the custody order that had come out. So Dalton makes the relationship with the children central to his case and opens the door. When you actually look at his defense, none of his witnesses apart from him have anything to offer other than the children were mean and nasty to Dalton. They didn't like him. They were rude to him. None of his witnesses had any evidence to offer that was relevant to the charges. Dalton made his relationship with the children central to the case, and the state is entitled to rebut that, and that's the proper purpose for this evidence. It's offered to rebut Dalton's assertions. It's offered to explain the victim's behavior. It's often offered to explain the children's behavior. And the only reason it comes in is because Dalton opened the door to it with his defense. But when you look at the other act evidence, it's all properly admitted. It's offered for a proper purpose. Again, it's offered in rebuttal to Dalton's defense. It's offered to explain the victim's behavior. It's offered to explain the children's behavior. All of those are proper purposes under Rule 404. There is no dispute that Dalton committed the other acts. He admitted to the abusive behavior towards the children on the stand, so the acts are established by clear and convincing evidence, and the trial court properly instructed the jury they cannot consider these acts for any purpose other than to explain the victim's behavior. And unlike in Chantry, the prosecutor here was clear with the jury that they could not consider this other act evidence for any purpose other than to explain the victim's behavior. She did not argue that the jury could consider this for a propensity purpose. She was explicit in her argument that they cannot convict Dalton simply because they thought he was a bad father or a bad person, and that the evidence was offered for a very limited purpose. So the only real issue is the evidence. The prejudicial effect of the evidence, does that substantially outweigh the probative value? And it did not. The evidence was highly probative to explain the children's behavior. It's highly probative to explain the victim's behavior, and it's highly probative to rebut Dalton's defense. While it is prejudicial, it's not unfairly prejudicial, particularly when Dalton is the one who opened the door to all this evidence in the first place.
Is this the same prosecutor as the prosecutor in Chantry?
Yes, and when you look at the record, she makes comments indicating that she wants to avoid the issues that this court found problematic in Chantry. But Chantry really has no bearing on this case. It's factually distinct. It's legally distinct. And in addition to being a memorandum decision that doesn't have any precedential authority, and I would argue doesn't even have persuasive authority because there's established precedent that adequately addresses the legal issues here. If this court doesn't have any other questions about the other act evidence, I'll move on to address Dalton's argument about the indictment not providing him adequate notice. The indictment did provide Dalton adequate notice. It laid out the elements of the offenses. The date of the offense is not an element of the offense, so it gave Dalton notice of the charges against him. And while it did provide broad date ranges, the date ranges were not such that Dalton could not present his defense. He could have presented an alibi evidence. He could have gotten his work records together and showed I was not here on these days. He was able to present some alibi evidence. There was a U-Haul receipt that showed that the family had moved.
But not when it's amended. Not when it's amended at trial, right?
Well, the amendment issue is really distinct from the notice issue, which is why I addressed them separately in my brief. But the amendment, he was still able to addressed that in his arguments about the amendment. He pointed out in closing arguments that he wasn't living with the victim during part of the expanded date range for the count. And again, he was able to offer some evidence, such as the U-Haul receipt that showed that they moved. In his closing argument, he pointed out how there were discrepancies about the layout of the house because the family lived in two different houses during the time the sexual assaults occurred. One was 2 stories, one wasn't. So he was able to point those things out. But the date ranges themselves did not prevent Dalton from being able to offer some evidence or alibi evidence. He could have gotten, again, his work records together to show I wasn't here on these dates. I believe the count 1 was the one that was alleged to have occurred in December, and he was able to offer evidence about that the family went on vacation around that time. So he was still able to offer an alibi defense, but ultimately the date ranges themselves don't deprive him of notice, and State v. Hamilton, which I cite in my answering brief, I believe is instructive, and I'm quoting from the decision where the challenge counts charge the defendant with commission of one specific act against one specific victim within a specific time period. The victims testified as to the specific occurrences that form the basis of each specific count, and the state clearly delineated during closing arguments which specific conduct constituted the offenses charged in each specific count. Although the indictment does not allege time periods in which the offenses were alleged to have occurred, ranging up to a year, defendant does not show any actual prejudice therefrom, and a footnote notes that the lack of an ability to present an alibi defense is a theoretical prejudice that's applicable anytime this sort of date range is alleged. And here Dalton doesn't establish any prejudice. If for no other reason, then he could still have presented his alibi defense. It may have been more difficult to do so, but he could have presented his defense, and he did in fact present some alibi evidence. Regarding the amendment to the count, the record supported it. The victim testified she wasn't sure of the specific date the event occurred. She was able to provide some detail about what was going on in the family when it occurred. And so the record supported expanding the range of the indictment, and he doesn't establish any prejudice from the amendment. It's a technical amendment. Again, the date of the offense is not an element. It just corrected the date on which courts in the state have routinely affirmed amending indictments to correct dates during trial. And if there are no other questions on that issue, I will finish up by addressing the prosecutorial error claim. Dalton, in his briefing, really wants this court to view his claims of prosecutorial error in a vacuum, but the U.S. Supreme Court has made it clear that context matters when you're reviewing claims of prosecutorial error, and the majority of the claims he's raising came out during the state's rebuttal closing argument, following Dalton's closing argument, which was fairly inflammatory. The defense counsel insulted the victim, insulted her religious beliefs, called her a marriage martyr, called her a master manipulator, argued that Dr. Foreman was biased against Dalton because of some notes that he quoted from in his closing argument. And so the prosecutor is entitled to respond to those in her rebuttal closing arguments. None of the individual claims or instances Dalton asserts amounts to a claim of prosecutorial error, let alone prejudicial prosecutorial error. And while he doesn't have to establish each individual claim is prejudicial for his cumulative error claim, the fact that none of them separately amounts to prejudicial prosecutorial error should lead this court to the conclusion, or I would argue, supports the conclusion that the evidence itself, or that there was no cumulative prosecutorial error that deprived Dalton of a fair trial. This court has no other questions. The state asks that it affirm Dalton's convictions. Thank you.
Thank you.
Thank you. This is not a case to play fast and loose with the record or these facts. It's interesting that the state on appeal can't even distinguish between the charged conduct that laid the foundation for count 5 and the other acts introduced that were not intrinsic to count 5. Contrary to my colleague's assertion, the shower rape that was referenced in the state's opening argument was not intrinsic to count 5. Count 5, the multiplicitous act argument on which count 5 was based on digital penetration of the vagina, in which MD testified she said no, and a vaginal penetration. Those were the two acts that rendered count 5 duplicitous and which the state made an election between at trial. The shower anal sex incident and the vaginal penetration in the shower were not intrinsic to count 5, nor were they related in time. I'd also like to note that on appeal, the state is now arguing that Dalton opened the door to the other act evidence, but that wasn't an argument that the state made in its answering brief. It didn't dispute that on this record, the prosecutor opened the door to the admission of the other act evidence in its opening statement or during MD's direct examination. And I would urge this court to review the transcripts closely, because the facts matter. As my colleague stated, context matters. So where does context matter? It matters when in the opening statement, the prosecutor raised the divorce revenge theory. It mattered when she described MD's repressive marriage and why she didn't feel that she could leave. She addressed Rodney's inability to take no for an answer, his excessive need for excessive sex. This was the state electing to make this other act evidence part of its case in chief. And it was so substantial that even on appeal, it's hard to distinguish between what was charged and what was other act. That's the problem with this trial. The prosecutor noted it below, the trial judge noted it below. This trial was about child abuse. More than half the testimony addressed uncharged other acts. And in fact, in addition to referring to that other act evidence in its opening statement, the prosecutor also used it for propensity purposes in closing. She did argue that MD's testimony, much like the Chantry oral argument, the Chantry closing argument, she argued that her testimony was corroborated by these uncharged acts, and therefore she was more credible. The prosecutor also urged the jury to believe MD was more credible because there was stuff that wasn't even read into the record, 2.5 weeks of evidence that the state hadn't admitted that would have supported MD's testimony. That the cross-examination questions that the prosecutor had accurately read into the record as paragon of virtue was evidence the jury could consider. The limited instruction that the court gave to the jury regarding its handling of MD, JD's other act testimony and HD's other act testimony didn't remedy this error.
Could any instruction have remedied what you perceive to be error?
On this record, no. The introduction of other act evidence was so overwhelming,
And
so
you
inflammatory.
reject the notion that your client opened the door in any way?
Absolutely. That's not supported by this record. Otherwise, the state can come forward, put these issues, address these issues in its opening statement and the testimony of its witness, and then turn around and blame the defendant for the very evidence the state introduced. Unless this court has any other questions, I respectfully request you reverse Rodney's convictions and sentences. Thank you.
Thank you. Thank you both for your arguments. We'll take the matter under advisement and issue our decision in due course. And at this time, the court's adjourned.